Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke and I want you to be a mock trial master. Let's talk about how you can make that happen. If you're new to mock trial, I'm really glad you're here because as those of us who have done this for a while know, mock trial can be super fun and super exciting. But if you're like me, when I first started mock trial and first started going to meetings and finding out what this whole thing was about, I had one very big question on my mind. How in the world does this whole thing work? What is mock trial and how does it work? Well, to put it simply, mock trial is a mock trial. It's a simulation of a trial, and every state and every high school and college, it looks a little bit different based on the rules of where you are. But simply put, you're going to be simulating a trial with other people from your school who are going to serve as your teammates, either as attorneys or as witnesses. And it's important to know, first of all, that witness doesn't mean a literal eyewitness. A witness can be anyone who has something important or relevant to offer to the case. Now, you may be sitting there thinking, oh, this is kind of a lot. I'm kind of overwhelmed. Don't be overwhelmed, because what we're going to do in this video is I'm going to take you through the 5 major elements of every mock trial so you understand exactly what they are, what happens during them, and what sort of the goal of each of those parts. As a preview, we'll be talking about pre-trial or preliminary matters. We'll be talking about opening statements, direct examinations, cross-examinations, and closing arguments. You ready to hop in? Let's do it. All right, pre-trial. This is the point in the trial where you'll see attorneys interacting with the judge and asking them some important questions about their preferences for the trial that's about to happen. You might see attorneys asking things like where the judge wants them to stand for various parts of the trial, if they need to stay at the podium or if they're allowed to have what we would call leave of the well, meaning just sort of free reign to move about the courtroom freely. You might hear them ask if they need to ask permission to approach witnesses or if they just have that permission and can approach witnesses freely throughout the trial. But the main point of pre-trial or preliminary matters is one thing, and that is to get everyone on the same page. You may run into some teams who look at pre-trial as an opportunity to show off their knowledge and stand up there and talk for 5 or 10 minutes. I can't stand that personally. I don't think it works. I don't think it's effective, and I don't think you need to. You can make a strong first impression simply by having a smile, by being comfortable and confident during pre-trial, and asking a couple of important questions, again, just to get everyone on the same page heading into the trial. Once you're through with pre-trial, you're ready for opening statements. An opening statement is exactly what it sounds like. It is a statement that opens the trial. The goal of an opening statement for both the plaintiff or prosecution and the defense is to preview the trial that's about to happen. You'll hear language in opening statements a lot of times like you will hear, the evidence will show, the facts will show, you're going to be convinced, right? These preview types of language, because that's exactly what an opening statement sets out to do. It sets out to preview the case. It does that by previewing the witnesses that you're going to hear from, the witnesses that your team is going to call. You do that by previewing the law, by explaining to the jury, hey, here's what the law is surrounding this case, and here's how you're going to see it play out today. And you also preview the case by just flat out telling the jury the story of the case. If it's a murder trial, you got to tell them the story of, Linda killed Bob, right? If it's a contract dispute that's made it all the way to a jury trial, you got to tell them the story of so-and-so signed a contract and didn't do what they said they were going to do, and now they need to pay up like the contract said they had to pay up. But again, opening statements for both sides, it's all about previewing the trial, telling the jury what to expect. Once opening statements are done, the prosecution or plaintiff will call their first witness, and with that witness, we'll have a direct examination. A direct examination is when a witness, who in mock trial usually is your own teammate, answers questions from their teammate attorney that are friendly to their side of the case. The questions during direct examination are open-ended questions, questions that for the most part start with who, what, when, where, why, and how. and that let the witness sort of be the star of the show. A lot of times in a good direct examination, an attorney will almost fade into the background and just kind of keep the witness going and let them be the star of the show. That's what makes a great direct examination great. During direct examination, a good team will continue to tell a story because every witness, for the most part, has a story to tell about their involvement in the case. You might hear from a witness who is a sort of main character in the case. Maybe they're the victim, maybe they're the defendant themselves, or maybe in a lawsuit, they're the person who filed the lawsuit. You might hear from an eyewitness, someone who saw or noticed something important along the way, or an expert witness, someone with scientific or other important specialized knowledge that is going to give some sort of educated opinion to the jury to help provide extra context to the case and make it make more sense. But in that direct examination, again, a witness is dealing with an attorney who is most of the time their teammate and who is friendly to their side of the case. Once a witness goes through direct examination from their attorney, the other side gets up and gets to cross-examine them. Cross-examination is a complete 180 from direct examination because we're no longer dealing with an attorney and witness pair who are friendly to each other. In a mock trial context, we're now in cross dealing with an attorney and a witness who are opponents, who are not on the same team, and an attorney who, number one, is going to want to pull facts out of the witness that are not friendly to their case, and an attorney who's going to want to steal the show from the witness. Right, a second ago on direct examination, I talked about how the witness needs to be the star of the show. The exact opposite is true with cross-examination. In a good cross-examination, the attorney is going to steal the show. And instead of asking open-ended questions like who, what, when, where, why, and how, the attorney is going to ask very tight, very rhythmic, close-ended, or leading questions that point the witness to the answer that they want. And for the most part on cross-examination, a good attorney is only going to ask questions that, number one, they know the answer to for a fact, or number two, they don't care what the answer is. It's all about recontrolling the narrative after your witness has gone on in direct examination to talk about the things that help the other side and bringing them back and sort of reminding everyone of some facts that are going to help your side. If you want to watch an example of a great cross-examination, go to my film sessions playlist on the main channel page on the Mock Trial Masterclass YouTube channel. There's a really great cross-examination example that's going to help this make a lot more sense, along with great examples of pre-trial, opening statement, direct examination, and closing argument, which we're going to talk about in just one second. But before we do get to closing argument, I want to let you know that my book, Mock Trial Masterclass, is available on Amazon. And if you're just getting started with mock trial, this is the guide you need to set you in the right direction. I've said before that I wish I had this book when I first started in mock trial because it's the complete roadmap to getting started as a mock trial attorney or witness, or even if you've done this for a while, there's plenty of tips in here that you can apply to your performances as well to take them to the next level. But whereas in this video, we're just talking about these things for 10 minutes or so, this is a deep dive. It's going to take you through openings, direct, pre-trial, cross-examination, and closing argument, and help you understand exactly how to create and write each one, how to prepare them, and ultimately how to deliver them well on competition day. And if you want to pick up a copy of the book, you can click the link in the description on YouTube or in the show notes on podcast platforms. We've made it to the end. The last element of a trial is going to be closing argument. Now, whereas with opening statement, we made a statement, right? We previewed the trial. With closing argument, we're done with statements. We're to the point of arguing. Now, in opening statements, you're not even allowed to argue, but when we get to closing arguments, you need to make sure that that's all you're doing. A lot of times I see teams in closing arguments just kind of turn it into what I call second opening, where instead of giving a preview of the trial, they give a recap of the trial. This is not a recap, guys. A great closing argument is going to take all of the evidence that came out during a trial and put it all together and contextualize it all and be persuasive to the jury and sort of say, hey, remember what you heard today? Here's why that points to my side of the case being the one that you need to rule for. Again, closing argument. It's all about arguing. You're not making a second statement. We took care of that in opening. You're going to argue in a good closing argument. Both sides will do it. In a lot of cases, the plaintiff or prosecution will get a chance to have a rebuttal as the last word, and then you can take a deep breath because you're done. Now, like I mentioned a minute ago, this is a sort of 1,000-foot overview of how a mock trial works and how each part of a trial works. If you want to dig deeper, there's plenty of videos on my channel on each of these elements of a trial that you can dig deeper, learn more about, and figure out how to get better at them. You can also pick up a copy of my book. That's a great, probably the easiest way to dig into each of these even more. And I can't wait to hear about you getting started with your mock trial career as you continue to learn more about this stuff, and I hope start to win and do it a whole lot.